Imagine this. You are sipping your second coffee of the morning, finally catching up on emails, when your boss walks in with the same energy as someone about to ask for your kidney. Hey, they say, we need to let go of Alex. No real reason, just not a good fit anymore. You blink, pause, wait for the punchline. It does not come. Just like that, you are being asked to pull the corporate equivalent of a drive-by firing. No explanation, no performance issues, just vibes. At that moment, your gut starts doing the cha-cha. This feels wrong. But is it illegal? Can you say no? Should you? Or is refusing going to land you next in line on the chopping block? In 2025's workplace reality, the line between what's legal and what's right can be fuzzier than an overused office sweater. But you're not alone in this mental tug-of-war. This article dives deep into what happens when you're asked to fire someone unfairly, offering the latest stats, legal boundaries, ethical insights, and even a few HR horror stories, with just enough humor to keep your moral compass from overheating. First, let's address the beige elephant in the room, at-will employment. In the United States, this doctrine means that employers can fire an employee at any time, for any reason or no reason at all, as long as it's not illegal. Sounds wild, right? But it's been the default setting for decades. In theory, it gives employers flexibility. In practice, it opens the door to some very questionable decisions, like firing someone for taking a sick day or because their boss didn't like the cut of their jib, or their sandwich in the break room fridge. Of course, just because something is technically legal does not mean it's morally or strategically sound. Firing someone unfairly may not break the law if it's not tied to protected characteristics or retaliatory motives, but that does not make it right. Nor does it mean it won't come back to bite the company, and possibly you, in a darkened HR conference room with no coffee and a lot of questions. The law draws a firm line when it comes to wrongful termination. That's when someone is fired for an illegal reason. Think discrimination based on race, gender, religion, disability, or age. It also includes retaliation for whistleblowing, or for exercising rights like filing a harassment claim or taking protected leave. In fact, as of 2024, public policy exceptions to at-will employment are recognized in 42 states. That means if someone is fired for refusing to do something illegal or unethical, they might have a very strong case in court, and your role in executing that termination might be front and center. You might be wondering, just how common are unfair firings, and how often do employees fight back and win? The answer may surprise you. According to a 2022 survey by the National Employment Law Project, nearly 69% of U.S. workers who were terminated in recent years said it was done without warning or a clear reason. In many of these cases, the employee was blindsided, escorted out with a box of personal items and a 1,000-yard stare. Even more troubling, 72% of those workers said they were not even given a chance to improve or address the supposed issue. And it's not just about feelings. It's about settlements, lawsuits, and PR disasters. Statistics compiled by legal firms such as Setian Law and Wenzel Fenton show that wrongful termination cases are not only being filed more frequently, they are being won. Workers represented by attorneys in such claims succeed in approximately 64% of cases. Without legal help, that number drops to 30%, which still isn't insignificant. The average settlement for represented claimants hovers around $48,800, but cases involving clear discrimination or whistleblowing can easily climb into 6 or even 7-figure territory. Over 90% of these cases are settled before they ever reach a courtroom, meaning employers are willing to pay, and often pay big, to make them go away. What about you, the middle manager, HR pro, or unsuspecting team lead caught in the crosshairs? If you go through with an unfair firing, you may find yourself in legal jeopardy too, especially if it's tied to a protected issue. You could be called to testify. You might be named in the complaint. You could even face disciplinary action if the company ends up settling and looking for a scapegoat. Meanwhile, if you refuse to do the firing, you risk your own job security. That's the soul-splitting paradox of modern management. Do you obey an order you know is wrong, or do you stand up and risk becoming collateral damage? If you choose to obey and fire someone unfairly, the fallout can be wider than you think. The employee might sue the company, naming you in the process. Even if you're not liable, being involved in a wrongful firing can tarnish your reputation, internally and externally, not to mention the emotional toll. Managers have reported experiencing guilt, stress, and even burnout after being pressured to carry out unfair terminations. On the flip side, if you resist, you could be labeled difficult, insubordinate, or not a team player, that ambiguous term companies love to weaponize when someone dares to have a spine. Let's take a moment to talk about performance improvement plans, the HR world's favorite pre-firing cocktail. While framed as a helpful tool for struggling employees, PIPs are often used as a paper trail to justify firing that's already been decided. According to recent reporting from the Wall Street Journal, the use of performance improvement plans as a pretext for firing has surged, with 43.6 out of every 1,000 employees being placed on a performance improvement plans in 2023, up from 33.4 just a few years earlier. Workers increasingly see the performance improvement plans not as a lifeline, but as a slow march to the gallows. And let's be honest, it doesn't take a legal scholar to see when something smells fishy. When an employee with good performance reviews is suddenly slammed with a vague performance improvement plans, or a team member who raised safety concerns is the only one laid off in a restructuring, the odds are good that fairness is being sacrificed on the altar of convenience. If you find yourself in the middle of one of these ethical train wrecks, you do have options. The first step is to document everything, every email, every meeting, every directive. This isn't just to cover yourself legally. It's also a way to clarify whether the firing is truly unfair or just poorly communicated. Next, ask questions. Lots of them. What's the documented reason for the firing? Has the employee been warned? How does this align with company policy? The more questions you ask, the harder it becomes for someone to dismiss your concerns or claim plausible deniability. If you still feel pressured to go through with an unfair firing, consider raising the issue with HR or a higher-level manager. If your company has an ethics hotline, use it. And if all else fails, you might need to consult a lawyer, not necessarily to sue, but to understand your rights and protections if things go sideways. In some cases, resisting the order may ultimately lead to your own exit. That's a hard pill to swallow. But for many, keeping their integrity intact is worth more than a few more months of job security. Now let's look at a real-world scenario to bring this into focus. Imagine you're a warehouse supervisor. One of your team members, Lisa, reports repeated safety violations to HR a week later. Your manager tells you to fire Lisa. No explanation. Just budget cuts. Coincidence? You doubt it. This is classic whistleblower retaliation, one of the most legally protected types of wrongful termination. If you go through with it, Lisa could sue, and your name will be all over the paperwork. If you refuse, you may be shown the door yourself. So what do? Ethically, there's a clear answer. Legally, there are protections for people who resist unlawful orders, especially those related to whistleblower retaliation. Morally, you'll sleep a lot better at night if you resist. But practically, it depends on your company's culture, your leverage, and how much risk you are willing to accept. That's the gray area that makes these situations so challenging, and why there's no one-size-fits-all answer. So should you obey or resist? The safest, smartest, most human choice is to resist. But strategically. Ask questions. Document the heck out of everything. Escalate where possible. And if the company still insists on pushing an unfair termination, weigh your options. Sometimes the best move is to walk away. It's easier to find a new job than to fix a broken moral compass or defend yourself in court for a firing you never believed in. In the end, it comes down to this. Who do you want to be? The person who blindly follows orders, or the one who speaks up, even when it's uncomfortable? The corporate world might reward compliance in the short term, but integrity has a much longer shelf life. And if you ever find yourself in that room again, sipping coffee as your boss slides another unfair ask across the table, just remember, you always have a choice. It might not be easy. It might cost you something. But sometimes the bravest thing you can do in business is simply say no. Because obeying might keep you employed, but resisting might just keep you human. And there you have it. Firing someone unfairly might be legal in some cases, but that doesn't make it right. If this video gave you something to think about, or at least made you chuckle uncomfortably, go ahead and hit that like and don't forget to subscribe. Until next time, stay curious, stay kind, and maybe hold off on firing anyone today.